Thank you very much for joining me again. In this short video or podcast recording, we're going to talk about duties to the client, in particular the duty of loyalty, and what that means for conflicts and for information barriers, two relatively tricky areas that you need to cover off. So again, I'm not going to go into any detail here. I'm just giving you a high-level overview of some of the things I think are important that might help you focus your study and your revision. We covered this material in week 7, and so you'll find it in some more detail if you go back to those recordings, if you feel you need a full refresher. It's one of the most significant areas that we covered, and it's worth remembering that when we think about the duty to the client and that duty of loyalty, we need to remember about the retainer as well, because the retainer, or the contractual obligations between the lawyer and their client, is really one of the key sources of the obligations, particularly when there is a current matter, so in relation to current client. But it will also inform the nature of the duty that the lawyers have to their former clients as well. And sometimes, or regardless of the contract, duties are going to continue, particularly the duty of loyalty, afterwards. And I've spoken in a separate video about the particular requirements to maintain a client's confidential information. So in the course, or in the lectures, and I'm sure in the tutors as well, we addressed a number of different ways in which in practice the duty of loyalty plays out. One of the most important of these is the requirement to ensure that you avoid conflicts of interest. And this is something that's become more and more complex and difficult to monitor as law firms get bigger and bigger, and the nature of the technology that they use becomes more and more focused on communication and the collection of data. The ability to collect data and to make sensible decisions about what might be in that data is better than it's ever been. So yeah, in thinking about the duty of loyalty, the duty to avoid conflicts of interest, and then the duties relating to information barriers, it's really valuable as you form your own opinions to think about the context of changes to technology and changes into the way that people do business. The relevant rules that you need to have a look at here, I would go straight to the Australian Solicitor Conduct Rules, in particular Rule 10, which deals specifically with conflicts of interest with former clients, Rule 11, which deals with current clients, and Rule 12, which I'll probably talk about in a separate video anyway, deals with conflicts between a solicitor and a solicitor's own interest and the client. So what's important to think about here is, where might we have the conflict? Is the conflict of interest between our personal or our personal interests and the interests of a client, or is it a potential conflict between the interests of a current client and another client, or a prospective client, or is it a conflict of interest between a former client, somebody we're no longer acting for, and a potential or a current client? So if we're talking about the potential for conflicts of interest to arise between two current clients, they're referred to as concurrent conflicts. And if we're talking about conflicts of interest between the duty of confidentiality owed to a former client and the ability to act in the best interest of a current client, that's called a successive conflict. Now, it's going to be important that you're able to distinguish between the two, because the consequences are different. As you're going through an IRAC, working out what the issues are and how to apply the rule will require you to distinguish between concurrent conflicts and successive conflicts. So, as a matter of common law, in Victoria at least, it's a solicitor's duty the solicitor's duty of loyalty to a client survives the end of the retainer, so the contractual relationship, and it can actually prevent a solicitor from acting against the interests of a former client in the same or a related matter. The key authority here is Spincode. We went through it in some detail in a lecture, and it is a valuable case for you to have good understanding of. Spincode has been followed and applied in a series of Victorian Supreme Court decisions, and while it has not yet, at least, received wholesale endorsement in other jurisdictions, it's well settled law in Victoria, and the LIV effectively say that solicitors would be wise to follow its rationale. Information barriers then will become particularly interesting because information barriers are the way that modern, particularly large law firms, manage conflicts of interest. So rather than rejecting clients out of hand, they will manage the process by setting up information barriers. They're really interesting because if you look at the case law, at least, really, we rarely establish that they actually work. So it's worth looking at the information barrier guidelines, and also take a look at Rule 10, which provides, so the ASCR Rule 10, which requires an effective information barrier in order to assume or to ensure, I should say, that the conflict is avoided. Key case in relation to information barriers remains Prince Jefri Bolkiah, and ultimately in that case we heard from the High Court that there's no rule that information barriers or other arrangements of a similar kind are sufficient to eliminate the risk that relevant confidential information will leak to those acting for the party with adverse interests. The starting point is always that unless a clear and convincing evidence can be available that all effective measures have been taken, then the presumption will be that information moves within a firm. And so the onus is on the firms to demonstrate the efficacy of their information barriers. Again, this is a really interesting area to think about where technology can help or hinder reaching that presumption. So the presumption, if there is a conflict, a firm cannot act because information travels. The presumption, of course, is rebuttable. Other than, look, in criminal law and family law, we saw that it's virtually irrebuttable because the perception matters. And this is where the duty that lawyers have to the administration of justice and to the courts steps in and sits above the duty to the client. So even though the duty to the client is clearly very important here, one of the reasons why in criminal and family law, and I had a few questions about this at the time, but one of the reasons why it's a virtually irrebuttable presumption is that it is so easy for people to perceive that there might be an issue or that there might be some kind of conflict or sharing of information that isn't appropriate, that it's virtually, basically there's a virtual veto. Do not act if there is any kind of conflict in a criminal matter or a family law matter. In other cases, ultimately it's still truly exceptional. The court would need to see clear and convincing evidence that effective measures have been taken, and the burden of satisfying the court is a heavy one. So in working out what effective measures are, you need to think about this. Now, clearly technology will be relevant to this, but we're looking for structural separation, we're looking for independent operation within the firm. Procedures would need to be documented, there would need to be evidence that they're followed, there would need to be recurring education programs within the firm, monitoring of compliance, there should be consequences if there is a breach, and extensive undertakings. And another interesting issue that we'll cover off, I'm sure, need to be given to whether it's a current client or a former client in relation to the maintenance of the protected information. Again, as I mentioned before, this is a particularly interesting area for you to come up with your own opinions, particularly because it interfaces with the ways that technology and business structures are changing so much. Questions, concerns, compliments, frustrations, you know where to find us.